Hughes, he's present, Your Honor. He has no problem walking. On Ms. Foster, we would respectfully waive probable cause, Judge.
The prosecuting witness is.
He's here, Your Honor. Her mother's husband.
Sir, if you would come up to the box, you have your ID. If you would speak into the box, what would you like to say, sir?
I'd like to drop charges.
So once the charges are filed, it becomes the state's case. So the charges won't be dropped today. Are you requesting any type of stay away?
No.
Are you concerned for your safety?
No.
Has anyone threatened or coerced you to be here today? Are you asking for any specific bond or bond conditions?
No.
All right, thank you, sir. Is there anything, will you waive probable cause?
Yes, Your Honor.
Is there anything from the state?
Nothing but the burden.
Four.
Thank you, Judge.
Ron?
February 17th.
220.
220. Thank you, guys. Thank you, Judge.
This was a site, Your Honor.
Morning, Judge. John O'Shea for Mr. Baldwin, probable cause on the felony.
Good morning.
I'm sorry, you said this was,
Site.
I'm sorry, you said waive probable cause.
Take care of that.
What number OVI is this?
First and first.
First,
First.
You're gonna send it with, you're gonna send them both? You're gonna send them both to grand jury?
Yeah, they've been sending both the
Okay.
drugs and the OBI would have been.
Was there FRA?
I believe we're shown, yes. You should have been first.
Yes.
Accident?
No,
No, it's a running car where he's in the car running with him with a little bit of heroin. In the sleeper.
He was asleep in the car. There wasn't an accident.
Refusal?
no,
Blood
blood's
test.
pending.
Oh. ALS?
There isn't one, Judge, since he
Got it.
submitted to the blood
Right.
test, so we would ask for a public safety suspension pending the outcome of the case.
Judge, he cooperated. He's got no priors.
I will do a public safety suspension at this time until Love comes back. He showed up today. It'll be an OR bond.
Did you say a public safety?
I'm sorry?
Did you impose one?
Yes.
Would you, can you give them privileges for doctor's appointments?
It's for your OR bond, they'll be expecting you to go to
May I approach real quick?
Foster.
220.
Yeah, when I'm up here. All right,
Oh, do we have a date? Mike?
23rd.
Okay.
Is that on everything?
Yes.
Thank you.
all right. OR, on both, public safety suspension is imposed. Driving privileges are granted to and from work, medical, and court with proof. Defendant will be put in randoms if defendant starting today. If defendant tests positive for any non-prescribed substance, you'll have to show proof of prescriptions. The driving privileges shall immediately be revoked.
Thank you, Judge.
Thank you. Con,
Brianna Betts Davis.
Good morning, Your Honor. Jeffrey Witt for the defendant. He's on his way out. Judge would like to enter a plea of not guilty. We waive preliminary hearing.
all right. Esteban.
Esteban?
Mhm.
Judge, my client's 32 years of age. He turned himself in in District 3. He's been a resident of Hamilton County all his life. It's my understanding he has no felony convictions or violent misdemeanor convictions. The alleged victim's been on other cases. He does live where it's allegedly happened. And we don't think it's going to pass the scrutiny of the grand jury at all, Judge. He actually was at his house with his mother and father when this alleged break-in even occurred. So we look for a very reasonable bond on this, Judge.
From the state.
Your Honor, I will agree that whether or not Miss Brianna Betts Davis participates is going to be determined whether or not this goes forward as a felony. However, there is some prior history between these two about a violating protection orders. I got convictions on 2 of those with the same parties, one from 23 and one from 19. There are other cases since then where I don't have her participation, so it makes it hard to figure out what exactly is going to happen. She's not here today, I know, but at the time of the offense, she definitely wanted to go forward with these charges and told the officer that he did not live there.
Judge, the TV's allegedly broken. He paid for it. He lived there. You can't vandalize your own property.
And if you move that. 5,000 anyway, plus EMD open hours, plus jurors if requested. Sanchez,
17.
217.
Thank you, Your Honor.
Good morning, Your Honor. Maggie Stork on behalf of Mr. Sanchez, standing in for Liam Dowling this morning. We're before the court on a bond revocation. Your Honor, Mr. Sanchez has been on this bond since November 1st, 2025 without any issues. That's over 3 months from this alleged violation. In the violation, Mr. Sanchez is cited for not charging his unit properly. He understands he needs to keep that unit charged because he is under that sanction of the court at this time. Your Honor, it does say they did a home visit and that there could have been a potential issue. We do contest as to some of the details surrounding that contact. However, I think it's important to note that when they did the home visit, Mr. Sanchez was exactly where he was supposed to be, which was at home. Your Honor, he's abided by the conditions of his bond. He has no felony history, no criminal convictions, no history of violence. Your Honor, he has no failures to appear in the last 24 months. He has residential stability in his own home. He has 2 pets, 2 cats, a tabby cat named Lamasa and a long-haired gray cat named Ms. Kitty Cat that he'd like to get out and take care of, Your Honor. He has the support of his father, Mr. Dan Sanchez, who was supposed to be in court this morning. I don't know if it was the weather or what could have delayed him from being here, but that is a good ally that Mr. Sanchez has. Your Honor, he has 3 ORAS points, but I'd like to point the court to the fact that that's for not having a job at the time of his arrest and his age. He doesn't have any sort of history that would make him have an ORAS score of 3 in a sort of negative way. He's complying with Mr. Dowling, staying in contact with him throughout, the pretrial phase of his case. And at this time, we would like the court to consider just giving him a straight OR bond based on the fact that he has been compliant with this. He doesn't have any failures to appear in the last 24 months. I did review his failure to appear history, and it looked like 3 out of the 4 capiases were when he was unrepresented. The one capias that he did have an attorney on was in 2023. I can attest that that attorney was with the public defender's office. And in that year, we did have to do a reshuffling of that attorney's caseload twice. So there could have easily been a communication gap coming from the attorney side 3 years ago. We'll submit on that, Your Honor.
Is there anything from the state?
I'll defer. The only thing I'll note is that the bond revocation complaint alleges he missed a bunch of office visits, which is a traditional.
It would be 1,000 anyway on each count. Stanford.
Good morning, Your Honor. For the record, Dan Might standing in for Rob Jones on behalf of Mr. Sanford. Judge, I'm moving to waive Mr. Sanford's appearance. He's been held since since January 20th on another charge that Rob Jones represents on. And he was given the opportunity to come down to court today. In light of the fact that he has counsel, we're comfortable just asking for a grand jury report date and a reasonable bond and waiving probable cause.
From the state.
Your Honor, this appears to be a stolen car that was found with the defendant in it 25 minutes after it was stolen. So there's some indication that he's involved in a theft. Now, it was left running with the keys in it, which is sadly becoming all too common in my world. But the defendant's asked, he said that he got the car from his people.
20,000 anyway. Fall.
Ranger 217.
Thank you.
Morning, Your Honor. Morning. I think this might have been on the docket yesterday, Your Honor.
You released me for that. You released me yesterday. I was inside of here. They put new charges on me from inside.
Your Honor, what I have before me is just the CRB number that I believe you had before you yesterday. I think he was going to be released. Which involved the January 12th disorderly conduct. So I think he was going to be released yesterday, and then he says maybe there was a new disorderly conduct filed while he was still in the JC yesterday.
Yeah, there was a DC file yesterday. Oh yeah, because because we had this conversation, it's set for trial on Monday.
Yeah, we sent it to you there on Monday. So I guess it came in after.
I only have one case number. Is there two now or are there?
He was arrested on a new disorderly conduct that I believe that we had in here yesterday that we resolved by way of a plea. And then this was pending, so there was a bond violation filed by EMU after we resolved that case.
Is this a 4 or a minor?
It says a 4. Well, the 742 number, that's the one I have is a 4.
Do we want to resolve this today since he spent another night in jail? Are we done with this?
State will move to amend to a minor misdemeanor if he's willing to resolve today.
Plead guilty to get it done, just go home again.
Yes, sir.
It's a minor misdemeanor. Maximum possible penalty is $150 fine plus costs. You do have the right to a trial, to a jury trial. Knowing your right to trial, the maximum possible penalties, do you want to maintain a guilty plea to the minor misdemeanor disorderly conduct? Counsel, you waive and stipulate.
Yes, Your Honor.
That includes waiver of service of a new complaint and arraignment.
Yes, Your Honor.
1, credit 1, remit the fines and fees. If for some reason, hopefully there's nothing else holding you, I will be here till 4. So call your attorney if something is holding you up and we'll figure it out.
Okay, thank you.
Stanley,
Was it protection requested? Is it Liana Johnson?
What is it, spouse?
Please going to be not guilty. Mr. Bond Judge, he's executing the temporary protection order now.
the prosecuting witness present, Liana Johnson. All right. Testifying.
He's 18 years old, entirely denies the allegations. They've gotten in an argument, but it never became physical. I will note there's no noted signs of any sort of physical injuries. Nothing stated in the 527 or the police report. My client has no prior record at all, and he's got good contact information. I got a good stable address from him. He has executed temporary protection order, has no issue staying away. He said he intends to go stay with his friend while his case is pending. Very young judge, 18 years old, zero failures to appear. Unfortunately, he was working at Canes. He lost that job. He has no ability to post any monetary bond, Judge. I would note the bond recommendation states to refer to the prosecutor, Judge. Given his financial situation, given that he's executed temporary protection order, given that there's no visible injuries, I would be requesting the law bond, Judge.
From the state.
State Judge, we would be requesting a monetary bond, and to the requested based on the allegations that there was a physical altercation with the defendant placed his hands around the victim's neck and choked her, as well as pushing her to the bed and punching her in the neck. I will also note that the officers wrote down that while he was in the Hamilton County Justice Center intake, the defendant stated that once he got released, he would violate the TPO and flip the victim's shit.
$5,000 anyway, plus juries if requested.
Huh? TPS said, sir.
Oh. Don't say anything, it's gonna make it worse. I'm talking.
Just wait on that. $500, that is your judge. I'll be careful what you say. Okay? 554.
Deshaun Cook.
Morning, Judge. Cook. You want me to green more?
Oh, we're gonna resolve this unrelated traffic matter, physical image charge.
Tenant, the 25 tenant window.
Correct.
All right, guilty.
Yes, Your Honor.
Mr. Cook, a guilty plea is a complete admission of guilt. This is a minor misdemeanor. Maximum possible penalty is a $150 fine plus cost. You do have the right to a trial. Knowing your right to trial, the maximum possible penalties, do you want to maintain a guilty plea to a tinted window violation?
Yes, ma'am.
Counsel, do you wait and stipulate?
Yes, Your Honor.
Guilty, Mr. Cook's been here one night.
Correct, Judge. And he's currently unemployed.
Is there anything from the state?
Nothing completed from the state.
One, credit one. Remove the fines and costs.
Thank you,
All
Judge.
right, as to the felony.
Please support, Judge. Good morning. We're going to waive a probable cause hearing on this. As for an OR bond, Your Honor, potential drug court case, good address, good phone number. Can't post much of a bond, given the fact that it's not working at this time. Help him with drug court, Judge, if he is indicted on this case.
From the state,
We'd agree to OR fund, yeah.
it'll be a supervised OR because there are a couple of failures to appear. Mr. Cook, you need to make sure that you stay in contact with your attorney so you know your court dates, all right?
Yes, ma'am.
Thank you.
Thank you, Judge.
Frey,
220 for grand jury.
Pre-trial and that, yeah. All right.
Is that on everything or just?
Yes.
He called Fry first.
is it Frey or Fry? Jamie Fry.
Brian Goldberg? Oh, I'm sorry.
Right here.
Good morning, Your Honor. My apologies. We're gonna waive probable cause.
As to bond.
Your Honor, with regards to bond, I don't think Ms. Fry has a terrible prior history. The assault here is based on her allegedly kicking a EMT officer. It does not sound like there is any intent here in kicking this EMT person. It was a very kind of volatile situation. She does reside with her mother. She's hopeful that she could go back there. She is released. Based on her lack of any significant prior history, I don't think there's any felony history that I'm aware of. I would ask the court to consider her for an OR bond.
From the state.
Your Honor, the most concerning thing is that the allegations are that she's been binge drinking for days when this thing happens. She actually punches out a glass garage window, sustaining cuts on her hand, which required the police and firefighters to be there in the first place. During that interaction, then she kicks a Springfield Township medic who's trying to assist her. So that got her the felony charge.
Just certainly believe that some type of supervised OR bond could assist her with any substance abuse issues that she may have.
We'd ask for a no alcohol.
OR plus tag plus no alcohol is a condition of bond. There's an allegation of spitting on here, so I'm putting communicable disease testing on here as well. Ms. Fry, you understand that you cannot consume any alcohol. You will have a monitor on that will alert your EMD officer if you do consume any alcohol.
Okay. Thank you, Judge.
Grand jury date 217.
Green.
Give me a call.
Okay, just let you know. Or, Your Honor, would the court, because of the blood test, I guess she won't get released today. Would the court consider maybe allowing her to report on her own to have that done?
What would she need
Make it a
to
condition of her
report
bond?
She wouldn't,
Huh?
we wouldn't be able to do the blood test until, they do it almost every morning at 7, 8 o'clock every morning, but they wouldn't be able to get it till 8 o'clock on Monday. So she'd be held until this Monday, unless otherwise specified.
Thank you for doing that.
So she needs to return Monday at 7.
If she's out, she has to do it on her own, unless
Okay.
pre-trial. Judge, I don't know. We just do those who are incarcerated. And she has to do that. She's got her insurance on everything.
I'll let you all work that out. It's a condition of bond.
I'll talk to her and make sure it gets done, Your Honor. Thank you, I appreciate that.
Green.
Your Honor, Mr. Green, we will waive probable cause. With regards to bond, I don't want to try the case here, but I will say with regards to the facts, this is a vehicle where 4 people were inside the vehicle. There was 1 gun found. I believe Mr. Green was sitting in the back seat behind the driver. The gun was found underneath the driver's seat. So I think there certainly is a proof issue here if he even does get indicted with this. His last felony conviction appears to be a 2019 possession of drugs. So I would ask the court, based on the facts here, to consider a low or OR bond. He also is employed. He works for Dr. Pepper. He's been there for several months. He just got promoted to supervisor, so he would like to get back to his employment there. So we would ask the court for an OR bond or a very low cash bond.
There are 4 people in this car at a traffic stop, but his prior is trafficking, and I think that's one of the police officers who he's the one with the gun.
Did anyone else get?
Everybody else got charged. There's some ecstasy. Other people in the car had ecstasy on them, so you're going to see one of them today.
But nobody else got charged.
Nobody else got charged with the gun.
And no one admitted. that
Nobody,
it was
no,
his.
nobody took any ownership of the gun in any way. I think it's more of a positional. They're claiming that the gun can't be put where it is except from the back seat, that there's a bar that blocks it from the front seat. It's under the driver's seat.
On the traffic, Capius is OR. On the new cases, OR plus EMD open hours. Would have been a straight OR, but you'll be showing up. There's 8 failures to appear. So it'll be open hours. You can go anywhere, anytime, but you don't have spots. All right? Thank you.
Thank you, Judge.
Harris.
220.
Sir, we will waive probable cause with regards to Mr. Harris. I will note there is an APA holder apparently on him, so I think bond is somewhat moot at this point. I will say he does deny these allegations. He tells me there's actually video footage that he has access to that will exonerate him in these offenses. So I'm going to speak with his mother, who apparently has this footage, to hopefully get that as soon as I can. But like I said, he does have the parole holder, so he cannot get out right now regardless. So we would ask the court for a nominal bond.
From the state.
Your Honor, the allegations are that she was choked and held at this place from around 5:30 in the morning until sometime like 12 hours later, 5 o'clock at night. She immediately then goes to her mother's house and calls the police from there, and is then told to walk in and go to a different district because she's calling the wrong one. So it's a walk in immediately after. So that's why you don't have police called out.
Officer Hay, I spoke with him directly. He noted that when speaking with the prosecuting witness, her voice was very soft and quiet, consistent with strangulation. She was having difficulty speaking. She had a large, pretty bad swollen black eye. He couldn't tell if there were any injuries to her neck because he said she's had darker skin, but she did immediately go to Good Sam for a strangulation kit. Allegations are that they were in a relationship since September, no children in common. There was additionally, he took her phone from her and threatened to kill her if she tried to call 911 or leave.
On the misdemeanors, 5,000 anyway. On the felony of the second degree felonious assault, 25,000 anyway. On the strangulation, 10,000 anyway. Holden,
17.
Thank you, Judge.
February 17th.
Yes. Yes. No, it's not.
Thanks, Jeff. Please support Your Honor, waive probable cause in the felony case. Judge, Esteban, good address, good phone number, good for drug court, prior client of mine. You can see some false comic books and a drug possession case appropriate for drug court, so that's for OR on that basis.
Regarding the misdemeanors, he suffers from Lou disease. He's treated 3 times a week at UC. There's no minimal record. Tells me he missed court largely because he was in North Carolina for a period of time during the hurricanes, doing work. He does tree service work. And he was also currently resides in Harrison. He's having transportation issues. He was with social worker here from the public defender's office. We talked to him today. He's going to get him connected with services judge, so that he's able to get here and also get a more stable housing situation.
from the state.
Does start off with comic book theft, Your Honor, but very expensive comic books because there's like apparently $1,500 worth of comics that are being placed in wrong containers or something like that. That it makes them so that they were underpriced. And then when arrested for that, there's methamphetamine.
This looks like Judge might could help with my office, if not drug court, so.
On the probation violations, I will reduce the capious bonds that the magistrate put on back to what the trial judge put on. So on the disorderly conduct, Judge Greenberg had a $3,000 bond. I'll put that on the paraphernalia, 1,000 anyway. On the new F5 theft by intimidation, 1,000 anyway. On the F4 possession, 1,000 anyway. On the misdemeanor theft or.
Your Honor, can we get a stay away from the Trading Card Academy as well?
I'm sorry, what was it?
Trading Card Academy.
I'm going to talk about that. Stay away. Decrease, Judge.
Lane.
We'd agree to no order. We'd agree to no order.
Nice job. We're busy together. Thank you.
217.
Waive probable cause.
Where probable cause, Judge.
Parties have already agreed to a OR bond.
Yes, Judge, I appreciate that. I want to tell you though, just specifically that he contacted me yesterday and I advised him to turn himself in 260. Already in drug court.
OR.
Thank you.
Miller.
20.
Waive probable cause.
Waive probable cause, Judge, please not guilty. Judge Esteban, I do represent Mr. Miller on several pending charges. He's maintained good contact with me throughout that time. I do just want to point out to the court that the theft was filed in October. I did not know about it. Mr. Miller's been in court since then, so I'm not sure why that wasn't served prior to this. That being said, obviously the court can see he's picked up some charges while he has pending matters. We have had an in-depth conversation that he should not be driving. He understands that at this time. He works at Diversity in Hebron, Kentucky. It's a warehouse. He does that to support his 4 kids who he lives with. I have a good address for him, good contact information for him, for his girlfriend. Judge, I'm gonna ask for OR on the traffic ticket. Mr. Miller has about $250 to pay for bond this morning. So I would ask for an SOR on the theft or something reasonable that Mr. Miller can pay. I will also say, I apologize that Mr. Miller maintains that he returned the U-Haul and that they could not get in contact with him. Often I see these charged as UUMBs, so I don't know if it'll even make it through grand jury.
It is a failure to return a U-Haul, Your Honor. There is some cake that's due for another day.
On the theft in any way or alternative, OR EMD, driving without a license, OR the reckless operation, 1,000 anyway or alternative, OR EMD, reasonable control, OR. Owens.
17.
Owens. It says 17 on everything.
Please not guilty, Judge, waiving probable cause. Esteban, Judge. I have a good address for Mr. Owens. The complaint says that he has a Seattle address. He is not from Cincinnati, however, he has moved here and does have an address in Cheviot. So he is local at this point. Judge, he's been in Cincinnati about a month. He's been working that whole time, doing warehouse manufacturing. Judge, I will say that I understand that the assault allegation is against an officer. I don't see any injuries alleged. Also, Mr. Owens has injuries of his own. It's my understanding that perhaps there was a scuffle with another inmate once he got here, and then this charge was a result of that. I'm going to ask for an OR on the disorderly conduct. Mr. Owens has about $200 to pay for bond this morning. Given his lack of Hamilton County history, I would ask for 2010 on the assault.
from the state.
This thing starts off as a disorderly conduct at a bus stop where he apparently is yelling at everybody. He's arrested on that disorderly conduct. Then while being booked, there is another exchange or another scuffle with a inmate during the booking process. Then the arresting officer tries to subdue that, and that's when he headbutted the other inmate and then headbutted the arresting officer who's trying to just keep him from being violent with everybody. I don't have any local record. I'm not sure how much of that's a part of, I don't have a national, so I don't know how much of that's part of him not being from around here. Other than that, I defer to him.
I have one misdemeanor that was confirmed. There are other charges from all over the country that they weren't able to confirm dispositions on. On the felony assault, 5,000 secured. On the disorderly conduct, or Prather,
17.
Good morning, again, Your Honor. For the record, Dan Might, standing in for Gary Goldman on behalf of Mr. Prather. We'll waive probable cause.
is this sweet? What is this drug? What's the drug?
I've got crack cocaine. I got marijuana originally found, and then crack cocaine found on this. I got both.
Way probable cause.
I do, Judge. And as to Bond, Your Honor, he's 20 years old. He's a Cincinnati native. He attended Taft High School. He has a stable address on Elizabeth Avenue with his brother. I show 0 failures to appear. Judge, we'd ask the court to set low bonds.
From the state.
Your Honor, this appears to be a traffic stop where marijuana and cocaine are found in the car. Nothing much on that. There is a pending trafficking charge, though, that's going on. So I defer other than that.
On the paraphernalia, or on the possession and illegal conveyance, or EMD.
Thank you, Judge.
Zayad.
220.
I'm sorry, what was it?
Okay.
220.
Thank you.
Oh, sorry, that's in my bad.
It's 217.
217 on the
Judge, did you call Cody Saad?
Yes.
Judge, plead not guilty and waive proper cause for Cody.
Esteban.
Judge Esteban, I've represented Cody in a matter in juvenile court. I would let the court know that competency was a significant portion of that. He was he had his probation modified because he had uncanny compliance. I believe he would do the same now. Mother and father were always present at the time that he was in court. I had significant interaction with them. I believe that we're going to be in the same position here, Your Honor, but I'd ask the court to consider at worst a supervised OR for him.
mental health seems to be some issue. There's like a not stopping 2 different times for 2 different police officers, and then he says that Angels gave him the car when he finally does stop. So there's appears to be some issue going on.
I'm trying to get him re-engaged with the services that he had in juvenile court, Judge.
Supervised OR, I'm making on the failure to comply, no driving as a condition of bond. So if he is caught driving in addition to a, until valid license, if he's caught driving, then this bond can be revoked in addition to the penalty.
Understood, Judge.
220.
Warren.
Thank you, Judge.
Sit down where I want to do that in detail, okay? Your attorney call when I get up. He's our supervisor, Warren.
Right here, Mr. Moore.
Waive probable cause, Judge.
Yes. You said waive probable cause?
Yes, ma'am.
All right, he has no record except one minor misdemeanor. There are 2 prior failures to appear. He will, based on counsel, it looks like we're going to drug court.
Yes, ma'am.
Is there anything from the state?
Appreciate that. Thank you.
OR, these other ones, or
Thank
unless
you.
you want to take care of them.
We're gonna just resolve them today,
Okay.
Judge.
That's fine.
I believe it's gonna be plenty in count A, they're gonna dismiss the charge.
Mr. Warren, a guilty plea is a complete admission of guilt. This is a minor misdemeanor. Maximum possible penalty is up to $150 fine plus cost. You do have the right to a trial. Knowing your right to trial, the maximum possible penalties, do you want to maintain a guilty plea to a seatbelt violation?
Your Honor, I'm sorry, I misspoke. It was, you wanted to plead to be dismissed.
Oh,
That
the
was on
B.
me. I'm sorry.
Okay,
But they're both.
sorry, the license plate.
Yeah.
All right. The unauthorized license plate is also a minor misdemeanor, same penalty, $150 fine plus costs. You have the right to a trial. Knowing your right to trial, the maximum possible penalties, do you want to maintain a guilty plea to the unauthorized license plate?
Yes.
All right, Counselor, you waive and stipulate?
Yes, Your Honor.
Finding of guilty, he's been in one night?
Yes.
Is there anything from the state?
Nothing further from the state.
1 credit, 1 remit the fines and costs.
Thank you.
Thank you.
Witterson?
that 220 grand jury date? I think you need 220. Thank you.
If you want to call, you can. It's- Some judges like to call, some judges like prosecutor to call. So if you want to
I do
practice
not.
that piece of it,
I'll let you call. I'd rather shut up as much as I possibly can.
That's a change.
Yeah, I'm not Dave.
Judge, pleading not guilty, waive proper cause for Shante.
let's start with the new OBI. What number is this?
I believe, Your Honor, this is going to be a first in time, second overall. Yes, there was a prior 2012, so it's not in time. Or it is.
Oh, because this other one was never convicted, it's still pending.
Correct. So she has a pending.
So it's the second,
Yes.
all right, first in time on this one. Third, second. FRA,
FRA is marked
NA.
NA.
accident,
No, there's no accident allegations.
ALS. Oh, this is a refusal.
Yes, ALS with a refusal.
All right. All right, waive probable cause.
We do, Judge.
All right, Esteban.
Judge Esteban, this is, the genesis of this was some disruptive activity that Shante had nothing to do with. She was present there. What it appears as if is one of the persons who was a passenger in her car get out of the car and during a search, a gun was located. My understanding is that that person said multiple times that the gun belonged to her, that it was not Shantae's gun. That led to a charge of obviously child endangering. She's been interviewed by 241. Kids are with her mother, who's in the courtroom today. So that domino has led to a lot of other things, but that domino being the gun was not her gun. She didn't even know that it was in the car, it belonged to someone else. So that's the court to take all that into consideration. She is employed, she has 2 children, does live alone with those children, and obviously would like to get back home to them. She has significant family support. They're in the courtroom today, Judge. I think that at some point we'll be able to figure all this out, but I just want to make sure the court knows that all these other dominoes stem from something that was not her fault.
From the state.
Your Honor, this starts as a 2 a.m. assault run where the officers finally pull over the Nissan sedan in a dead-end alley. She has 5 open capuses. The problem then becomes that she appears to be intoxicated. There is a 4-year-old child in this car that is just wandering around in the car. There is another person there, boyfriend. She says, when asked to drink, she says she had about a bottle. Then once the gun is found, the gun is actually found because the 4-year-old child told the officers that there was a gun in the car, where the other individuals did not inform the officers that there was a gun in the car when answering that question. The concerning behavior is that you've got a 4-year-old in your car wandering around with a gun drunk at 2 a.m.
Judge, she does dispute that recitation. I would say to the court that obviously the safety of the child is going to be the crux of what's going on here. That child has been placed with her mother. So that should not hinder her being able to get out and at least get back to work to continue to provide for these children while she's in compliance with 241 kids, which she is right now. We ask the court to consider a supervised OR.
In Your Honor, in that regard, the misdemeanor should be requested an EMD alternative if possible. She can't post that on technology. OBI is 23. There's no credit.
There's also a 2012 child endangering conviction.
14 years ago, Judge.
Yeah.
So Ms. Witterson has a 2023 OVI that was not resolved because Ms. Witterson has been recited 3 times and has failed to show up to court 3 times, which is why this case is almost 3 years old, because every time she's cited, she refuses to show up. The state had 5 failures to appear. I have 9 failures to appear. The bond that a magistrate currently set is $20,000 plus EMD. I would lower it to $10,000 plus EMD on the OVI. On the red light and the driving under suspension, OR EMD. On the new, these are also KPS bonds, another set from May of 25. I'll make those OR. on the CCW ORND. The endangering children, 10,000 anyway, plus EMD, plus comply with JFS. On the OBI, 10,000 anyway, plus EMD, plus a TAD unit and no alcohol is a condition of bond. On the driving under suspension, OR, child restraint, OR, using weapons while intoxicated, OR plus EMD.
17 is the date.
217.
217.
Right?
Your Honor, Mr. Wright is a co-defendant with Damon Green, who we had earlier. Another F4 passenger.
Right. In the middle and no next to the other way.
You want probable cause?
We do, Judge. Please not guilty with probable cause.
All right, Mr. Wright has no record except for 2 minor misdemeanors. This is a F5 and no failures to appear.
Agree with an OR.
OR.
Thank you, Judge.
Weish,
Deed is 220.
I'm sorry.
220.
Why?
No, right here.
Good morning, Judge.
Waive probable cause.
Yes, with probable cause, enter plea of not guilty.
Who's representing?
I have the felony.
Okay,
Yeah.
usually you're.
Oh.
All right, it's fine.
Okay.
All right. Waive probable cause as to bond.
As to bond, Your Honor, what we're ultimately going to be requesting here is an OR bond. I want to start by talking about the facts of the case. This is from October 12th of 2025. The listed victim on this offense is Mr. Weich's girlfriend's mother. This is the family car that they all use and have all continued to use since that time.
Well, let me stop you real quick. Does he have somewhere to go on EMD?
Your Honor, he does have somewhere to go on EMD. We would ask if the court is considering EMD to allow him to turn himself in on Monday to do so. He works as a manager at Popeyes and works the night shift at 4. He works tonight, tomorrow night, and Sunday night. He is afraid that if he misses 3 straight shifts and can't get on the noon list today, that he will lose his job. That's why we were going to ask for an OR rather than OR EMU. I do know the court sees some failures to appear there. I talked with Mr. Weish about those. His understanding of it is there was a miscommunication with a prior attorney. He reached out to that attorney after he found out there was a capias, got recited, and resolved those cases from there. I'm confident we won't have those issues in resolving this case if it makes it through grand jury, which, given that the car has been returned and was returned within October, by my understanding, and was never stolen in the first place, I have doubts about what it will come back as.
Doreen Powell, I have similar issues with this, probably won't come back.
Supervised OR.
Thank you. Thank you.
220 is the date.
No. Supervisor OR.
They even got that. No, they even got that. Because I
I'm not my courtroom every day. Keep it
Yes,
safe.
it goes with it. No. You know, I actually like this courtroom better. You see, like, yes.
Left side, bottom. Right there. Anywhere right there, yeah. Thank you.
Yeah, because you don't come here. This is more exciting. What? You see, felony thing. Okay. So you do every day.
Every day.
You ever see Charles? Or you just want to do arraignments?
Same thing every day.
You probably won't see the outcome of that.
Not very many.
Did you?
$100.
Really?
I was like,
It ain't all rusted out?
I was like, buy two of them, three of them, everything. I was like, right? Yeah, I mean, you get a tractor supply store for $500.
Oh, yeah. And they
Is that my brother-in-law? I got mine from what prison that was being raided. They're going up there and muffling. Back there. Still around. It's still out there. Yeah, sit out with 7 feet.
Yeah, not outside. You're right. It wasn't 4 years.
I was like,
2 years ago.
Because Chelsea said. Which I never understood that.
Okay. We're gonna make this board.
yes.
I need Judge Wright's score.
She just needs to put a C in front of that OR.
I need something else.
We'll put this conditioner up here.
Yeah.
Supervisor.
But yeah, then finally, in the last 10 minutes.
We're Friday, right?
Yeah.
Yeah.
Well, she had written on there, she may return.
I was pretty good though.
I did see her.
He doesn't like Chelsea.
Well, I was gonna. I know. Yeah. All right. Then I'll need anything. I'll be. Yeah. You guys are great. Make it. You talk about walk
Well, they'll send him over there right after court.
I tried to just give him an update on Sunderland. Hopefully tomorrow.
Court is back in session.
We have Rico Say, Jamar Wilson. With probable cause.
This is Jamar Wilson, Your Honor.
Mr.
Or
Wilson,
Jamar,
press the
actually.
bond.
Mr. Wilson right there.
Yeah. I represent Jamar. Sorry, sir. Gonna waive probable cause, Your Honor, here like you should be.
Did I give OR comments?
Because the state.
Yes.
Their standards?
Appreciate that, Judge.
Oh, I'm sorry. I have James.
Jamar Wilson.
Jamar Wilson,
I do not have it, Jamal.
walk-in client, yeah.
How'd you know to be here?
Huh.
I brought it out yesterday, and it was like 24. I got paper.
You paid bond yesterday?
In my office, Judge has walk-in for this morning. Has representation now.
I got, we got the paper.
Later here, Mark. Just care about, yeah, when in doubt.
Yes. see it. Is there a bond sheet in the jacket?
Yeah, I'd rather he be here, Judge, of course. My client.
That's it.
OR? I think I said OR bond.
Yeah, I never received a paper.
Oh, no, he paid, oh, I said OR on the ones that needed to be sent, then he paid standard bonds on the other.
Okay,
Oh,
so we're good.
we figured it out.
Okay.
It'll be the same bond. Is there anything from the state?
Nothing, no.
All right, Mr. Wilson, just stay in contact, here's the function. Just stay in contact with your attorney, all right?
Thank you.
Do I get a new court date for it?
Yeah, we'll talk more about that. Get the 20th is the next grand jury date? 20th?
Is a day.
Okay, that's what I thought. Okay, thank you.
Rico Say,
Is that on everything?
Mr. Say received an OR bond, Judge?
He did.
Send it, yeah, send it all.
okay. All right, I gave Mr. Say a OR bond last night, he's here today, is there anything? Where does he need to stay away from?
Speedway.
OR plus stay away from Speedway.
Thank you, Judge. 220?
Ballard.
After we do this one, can we read Judge Bond on the one with the blood test for I? Sure. I have the judge sheets. We just need judge sheets changed.
I don't see everything in the pockets. I don't see everything.
Where that's on, this one.
Okay.
Ornyar, you're asked to bond, please not guilty. This does involve one bag of shrimp from September of last year, Your Honor. She did graduate from Remington College, unemployed right now. I think I OR'd.
Ask for a stay away from Board of Food Services.
OR plus stay away from Board and Foods, Ms. Ballard.
Yes, sir.
Thank you.
Yes, ma'am.
Okay, great.
Thank you, sir.
Cooper, oh, Fry, sorry. Jamie Fry, what do I need to do?
Judge, this is for the blood test. If we make this a supervised release, pretrial
Oh,
facilitate that. If you just have them report the pretrial on Monday for blood test, they'll talk during the back.
Okay. All right, so supervised, OR, everything else is the same.
Yes.
Was May returned to get blood tests on there? I mean, that's what we need to take it off.
Yes.
Okay.
Yeah, I just put plus communicable disease testing SOR. So then,
Results good to pretrial.
oh, put results, go to free trial.
Correct. Please and thank you. That's why we love pretrial.
It's a cut you in the back.
So don't let me try it.
Okay.
Thank you, Judge.
Cooper,
Do you want to take my information? Because I didn't do anything wrong.
Okay, good. Then let's just say no. Thanks. Morning, Your Honor. Yes. Your Honor, plea is not guilty. I do want to say that Mr. Cooper is 36 years old. He finished in the top of his class at Walnut Hills High School, and he wants the court to know that he was actually hugging the cars in the middle of the street. He was just being a little eccentric at the time, and it didn't really involve trying to impede traffic. He was just being eccentric. And I know that we have a competency report that came back about 2 weeks ago that came back competent. So I know the officer made it a note of mental health recommendation, but
It's for self.
I can say that I had him recently on a case and it came back competent. Thank you.
there anything from the state? There is only one prior failure to appear, so it looks like Mr. Cooper shows up to court.
We'll defer you.
All right, it'll be a supervised OR bond. Just make sure you stay in touch with your attorney, and whatever you do it on the side of this, okay?
That works.
Thank you, Mr. Cooper. Have a good day.
Thank you.
Average.
Ariel Keys, present. No response.
Yes. Your Honor, plea is not guilty for Mr. Everidge. He is 38 years old, Your Honor. He did attend college at ITT Tech, Your Honor. Looking at his record, his pretrial at the bottom of the sheet, Your Honor, I see very, very few contacts with the court system. For that reason, he's asking for a low bond.
From the state.
Your Honor, the allegations are the officers observed torn clothing and lacerations on the victim's neck. He said he grabbed her by the throat and ripped her clothes. And again, the officers could observe things that was consistent with that. He was up over a crying baby.
He is. He's signing the protection order.
We'll defer it, Your Honor.
Stay away from victims, alleged victims.
OR plus jurors if requested.
Thank you, Your Honor.
Holloway.
Is there a Lauren Lugan present? Lauren Lugan or Lugan?
Thank you, Devin. Keep that, sir. Child.
He is not guilty for Mr. Holloway, Your Honor. He is 36 years old. He will agree to sign the protection order this morning. And Your Honor, he did attend Cincinnati State where he got his GED and would like a low bond this morning. Signing that right now. Yes, Esteban, Your Honor, he is 36. He did attend Cincinnati State where he got his GED and he lives with his mother this time, Your Honor, and would ask for a low bond.
Your Honor, that's it. There's also a protection law violation with this. Another note.
It looks like this is the same person who is part of the other pending case. Yes.
Yes.
Same victim.
Yes, sir.
On the violating a TPO, 25,000 anyway, plus jurors if requested. On the BNC, 5,000 anyway, plus jurors if requested. Horny.
Sign, sir.
Attorney's gonna do all the talking. Very good, very good.
Your Honor, I think he missed court on February 2nd. He wants you to know he was in the hospital. He'd like to plead guilty today.
Good morning, Mr.
Good morning.
Guilty plea is a complete admission of guilt. This is a minor misdemeanor. Maximum possible penalty is a $150 fine plus cost. You do have the right to a trial. Knowing your right to trial, the maximum possible penalties. Do you want to maintain a guilty plea to a minor misdemeanor disorderly conduct? All right, Counselor, do you waive the stipulation?
Yes, Your Honor, yes.
Finding of guilty. Mr. Horny's been there for one night.
Yes, he has.
Is there anything else from anyone?
No, Your Honor. Yeah.
One, credit one, remit fines and costs.
Great. Thank you, Your Honor. Thank you.
Jackson,
Very good.
That's all I know. Right up there.
Jackson.
Your Honor, I see the case number 1531. I see that's set for a pretrial in 264. Judge Harris for a pretrial. So are we here on an EMU issue?
yes. The allegation is the defendant failed to abide by the rules of juris EMD. The defendant has been through the exclusion zone numerous times. January 29th, February 3rd, and February 4th. On February 4th, during a call addressing said zone violations, the defendant admitted to being in contact with the alleged victim.
And what she wants you to know, Your Honor, is they share children together, she and the father of their children. And she only contacted paternal grandmother to try to set up visitation. And that's all. And she believed that she could arrange visitation calling grandmother. And that's her explanation for the contact. I'm not sure about the exclusion zone issues, Your Honor. I do believe that if the court makes really clear today to her, she has to have zero contact with the alleged victim and his family. I think she'll abide by it. Is that right?
Yes. From the state.
Your Honor, it's very clear that she has an issue following the rules. I think when you get a juris monitor, it's expressly told you not to go into that exclusion zone. She went into it on multiple dates. It's not like this would have just, and if it was just for visitation, then that needs to be reported to her EMD officer. When somebody is told no contact with prosecuting witness, they're told no contact, and even if it relates to their children, while this case is pending. Allegations against any underlying involve striking the father of her children with a Stanley Cup multiple times. So we would ask that her bond be revoked and she be held pending the conclusion of the case.
Not only do they tell you you can't go around the person, they give you a map of where you can.
Yeah, I understand.
Hold on, I'm sorry. And then they also will send a message to you on your leg that says, alert, you're in the exclusion zone, alert, you're in the exclusion zone, get out of the exclusion zone. And then they call. Prior fine revoked, fine $2,500 anyway. Macau.
Yeah, on that last case, so I think she has counsel on 217. I don't think I should designate. Would you agree? If you,
Oh, already on that
I'm pretty sure because it's set for a free trial. I'm pretty darn sure she has counsel.
one. Yes,
So-
Maggie Morrison.
Okay, I'll just take it.
She-
Good.
No, just put Keith. It's already set. Mr. McCow.
Yes, yes, Mr. As to bond for Mr. McCow, Your Honor, the plea's not guilty, first of all. He wants you to understand that regarding unauthorized use from last year, that involves his wife's car, and the officer explained to him, you know, you're in your wife's car, and I guess there's an issue about using it and having permission. Anyways, they're back together. They have a child on the way. He's asking for an OR bond, Your Honor, and does believe that all these past issues involving his wife are resolved because they're back together again. And he will abide by any bond order, Your Honor. Thank you.
What does he want me to know about these 5 failures to appear?
So he wants to explain, he does have some court cases in Kentucky that have prevented him from getting to court recently. And he does live in Kentucky, so he has some issues with transportation to court.
From the state.
City has.
Both. From the city as well.
On the unauthorized use, same bond or alternative OR EMD, that's the 10334. And the 10335, same bond or alternative OR EMD on the possession of drug paraphernalia, OR EMD, open container, OR driving under suspension, OR license plate violation, OR the 3056, the entire traffic series there, OR. And then the 6913, there are 3 prior cases on that one case alone, OR EMD. On the 8338, there are 2 prior cases, so the bond is 2,000 anyway. Roads.
Would OREMD be added to that one, the last one, the 2,000? Awesome. Thank you.
Alternative OR EMD. Roads.
Sir, Sharnice Nelson.
Let me work down 10 minutes, but on detail. Very good turn. 10 minutes. Rose.
Oh, jeez. I'm sorry, Josh.
You're entering the plea of not guilty.
I am entering a plea of not guilty. Judge is 40 years old, single, got a good address on Peabody, good phone number for him. Works at B&R Printers, he's been there for 2 years where he's a machine operator. Graduate of Withrow, he had 0 failures to appear in the last 5 years, no convictions since 2019. I asked the court said no bond in this matter.
From the state.
The theft of an iPhone, Your Honor, we defer.
Supervised OR plus no contact with PW.
Call me when you get out, okay? You're getting out. Call me when you get out.
Rodriguez.
Judge, Mr. Rodriguez is over income, so I'm not submitting a designation for him.
Jelena Cole.
Get to that part.
Please not guilty, Your Honor.
Go ahead.
All right, Esteban.
Thank you, Judge. 33 years old, single, no children, good address, good phone number for him. Works at Elite Luxury Automotive. That's a business he owns. It's a car dealership. He's been in Cincy since 2013, although he's originally from Texas. And again, I would reiterate that he does own a business here. So I would think that the fact that he owns business here offsets any flight risk back to Texas. Has signed a TPO, 0 failures to appear in the last 5 years, ORAS of 0. I ask that the court set an OR bond in this matter.
With the signing of TPO, Your Honor, we defer the most prevalent aspect of this to me is that their children are present. All the things going on.
5,000 anyway, plus juris if requested.
Is there an alternative OR?
Sign, sir.
Salguero,
I said, I don't know, like, you know, also.
Not if she doesn't request.
Yeah. Sal Gura.
Right here.
Hello, morning.
Not guilty, Judge. As to Bond, 40 years old, married. She has 3 children, one of whom is disabled, who she is the full-time caretaker of. He is wheelchair bound. I have a good address, good phone number for her. She works home health care. She works 40 hours a week. It's a full-time job. Graduate of Taft, has her STNA certificate and a phlebotomy certificate. Judge, she tells me what happened here was she was coming to court on this. The judge was unavailable on a particular day. She was told to get out of here and they mailed her a court date, and she never got the date. Conceding that it is her obligation to keep herself abreast of her court dates. She has counsel now. I don't know if she did before. Certainly, I'll make sure that happens. I would ask that the court consider an OR bond here. Again, I reiterate that she has a wheelchair-bound son who she is the full-time caretaker of. And she hasn't been in trouble since she came to us in 2023. Thank you.
from the state?
Your Honor, ours are 22 cases. The city has 23s.
23 OBI, container, and theft from Kroger.
I'm sorry.
23 OBI, open container, and theft from Kroger.
We did really cool on ours.
It'll be the same bond or alternative OREMD.
She get out, but she got-
There is one of the capuses, I'm the judge, so I know when I was out. So one of the capuses I was. That's when I was checking. But one of the capuses, I was good in my seat that day.
Understood.
So that's why the EMD will be put on. I'll do open hours because of the nature of her job. She's not in one place probably.
Right.
So all I care about is the capuses and returning on the EMD.
I'll make sure I have a report, Judge.
Okay, I will. Thank you.
Thank you, ma'am. Smith.
Left. Is Duran or Mariah Smith? Duran or Mariah?
Duran Smith?
Duran.
Okay.
Lordy, Hypolite.
Please not guilty, Your Honor.
All right. As for
39 years old, single, 4 children, good address for him on Vine Street, have a good phone number for him, he resides by himself. Works at Tradesman International as an electrician, has been there for 3 years, graduated high school in Florida. He's been in Cincinnati since 2020. Judge, the only thing I would point out here from the complaint is that the protected party is not the one that called law enforcement. He has advised me that he was invited to the home of the protected party. Certainly, he still has an obligation to abide by the terms of that protection order. The protected party cannot dissolve the order, but I think that is relevant mitigation.
from the stage.
Just ask for stay away from Lordy, Hypolite, and Program.
Or plus jurors if requested. Smith.
Cool. She should be getting out as long as she doesn't have.
The Asian babe.
Please not guilty for Ms. Smith, Your Honor.
Is there anything from the state?
Just to stay away from Miss May.
It would be a supervised award plus stay away from the prosecuting witness.
I'm gonna get out of that.
Steinhauer.
Please not guilty on Mr. Steinhauer. As a bond judge, he's 36 years old, single, has 2 children, 9 and 11. Good address. Lives in Versailles, Indiana. He's got a phone number. Single father. He got laid off 2 weeks ago. He is, however, a member of the local union Laborers Union 265 there. Graduated of South Ripley High School. Judge, timeline here. So he picks up these 2 cases in December of 24 and February 25, so only a couple months apart. Shortly thereafter, he picks up a case in Kentucky, and he's been locked up ever since. There's a 10-month capious history here, but he was incarcerated outside of Ohio for most of it. Obviously, the elephant in the room, though, is picking up the new charge. These are theft offenses, recently laid off. I'd ask that the court consider an alternative REMD matter or bond. Actually, I don't know if we can do any in Indiana, so just supervised OR,
When did he get out of jail?
December.
So why didn't he show up when he got recited in May?
He was in jail.
When I got out of jail, and I was under the impression it was in February.
He's telling me he thought he was going to be recited to a court date. He thought he was recited to a court date.
I thought I was.
He was, he didn't show up.
In May, or
I was in jail.
he was incarcerated in May. He didn't get out till a couple months ago.
When?
When?
Was he released?
December the 19th or 18th, I believe.
Of 25.
Yes, ma'am.
And when did he go in?
February of 2025. My public defender on the case was supposed to have gotten that. She had told me she did, so that was the only reason that I did.
So Judge, I'm seeing March of 2025 Boone County probation violation. So I think that would be where he was incarcerated. And I'm showing here a February 12th date for that trespass 2025 case. So I don't know if that was cited in reset.
It was in a theft case. Either way, it'll be the same bond or alternative OREMD on the 24 case, OR on the new case.
That's for Staley from Myers, Your Honor, for mine.
Did we address the 25 CRB?
That's what I'm about to do, OR on that one. The judge had already said OR on that one.
So correct. 10% of $10,000 is $1,000, or at no REMD.
Alternative OREMD.
What's that?
You remember, Judge, that he resides in Indiana? I think if you lower that 10,000 to 10%, I think you could post 1,000 at 10.
$2,500 anyway. Or OREMD.
Perfect. Thank you, Judge.
Thank you, Your Honor.
Swenson,
Brian? Yeah.
James
For sure.
Swenson,
You ever been to Versailles, Indiana? Big
Is
lake.
this based on the 2024?
Versailles or Versailles?
Versailles?
Did you go to Princeton?
the Swenson.
Yes. Is that the?
Zero.
All right, the. Yeah, no, it's just the PV, physical control from.
Yeah, I see it's a probation violation filed September 9th of 2024. It's the only thing I can see in the jacket that we would be here on.
Judge, he was locked out the last 9 months in Indiana and got transferred here on his discharge date there.
I don't have anything. just got out of.
Yeah, discharged in Indiana, transferred here.
On the fifth. Is there anything from the state?
No, Your Honor, with the first.
You good now? Call me when you get out. I got a quotation for you. Okay? All right, thank you very much.
Did I go to question?
James Wilson,
Mr. Wilson's here, Judge. He posted, Bonnie's eligible for diversion.
did he post or do I?
Posted.
He posted.
Standard 1,000.
With the court's permission, I'll let him in.
Manual roll.
I told him to come in. Mr. Wilson, paid bond, will enter a not guilty plea on your behalf. It'll be the same bond and you'll just go get your court date.
Number 17, right down the hall on your left.
I'm sorry.
Stay away from.
Oh, and stay away from Kroger.
Your Honor, on the 10:30 docket, there are two ASAPs.
I have that,
Which one do you have?
both of them.
Well, you,
Yep. Yahya Malik was ignored. Hayden Rackett was indicted on 4 counts.
Do you know if the misdemeanors, right, were both, the misdemeanor and the felony ignored for
Yes.
Malik?
Yes.
Okay. And then there's a misdemeanor for racket. Was the misdemeanor included? or-
Yes.
Okay.
Robbery, aggravated robbery, felonious assault, and endangering children.